Okay, right. We have another caller from Ohio. Vivek, please go on.
Yeah, hi. This is Vivek. I submitted all the documentation with the logbox in October, but still I'm waiting for the receipt. I didn't get any of the receipt, and then there is no update for the logbox support email as well. I'm just wondering, is there any clue that you can give what we can do, or is it good to wait, or we can go ahead and stop that check and reapply? That's my first question. My second question is for reapplying, the dates are went back. Now it is 1/1/2014. So the dates went back for me. So what we need to do? Do we need to wait, or is there any other chance? Thank you.
First thing is, the answer is very simple. You cannot do anything. If you want to withdraw your case, that would be extremely wrong of you to do that, because you are missing a golden opportunity. Why would you want to withdraw your case? And how can you refile it if the visa numbers are not available? So even the thought shouldn't occur, it shouldn't come to your mind about withdrawing the case. This is an opportunity that's given once in 10 years, once in 20 years. And if you say you filed it in a timely manner and now you want to withdraw it and refile it, when? When are you going to refile it? Again, 20 years later? What was the purpose in filing it to begin with if you wanted to withdraw? So no, that is not the solution. If you have not received a receipt, wait. You're not the only one who has not received a receipt. Thousands of applications have not come yet. We have not received receipts. In our office and in many other attorneys' offices, they have received only 50% of their receipts, maybe at the most. And I-140 receipts, if there are any downgrades, those are very few. So my advice to you is wait, because there's nothing much else that you can do. You can keep periodically checking your checks to see if they're cashed. If they're cashed, then you can expect a receipt within a week or 10 days.
Yes, thanks for calling. And Prashanthi, I have a question. What if child ages over 21 during the period of adjusting status? Is there an effect or not?
Right. So there is an effect if a person. So when you're filing the 485, you file obviously for yourself and you file for your dependents, your spouse and your children as well. At the time of filing the 485, if you're filing your case based on final action date, which is not what happened in October, they allowed us to file based on dates for filing, which is only a temporary date. It's not an actual date that's available to you. So if you're filing based on final action date, then the date that you file your 485, suppose your child is 14 and the dates go back after you file, you don't have a problem, because the age of your child automatically freezes along with the as soon as you file the application. But the problem is that if you file based on dates for filing, which is like this artificially available date, then the age of your child doesn't freeze. So you're out of luck if you don't get your green card, and if the dates retrogress and you don't get your green card, then your child is out of luck, because they will age out. They have to be under 21 as of the date that your 485 gets approved for them to get the green card. So there is something called CSPA, Child's Status Protection Act, based on which what they do is they deduct the time that it took for the immigrant petition to be filed. So, and the time that it took for the immigrant petition to be processed, not filed. So if your I-140 took 6 months because you didn't do it in premium processing, or it took a year, or it took longer than that because there were some issues with the I-140, then they will deduct that time from the present time of the child, and your child will artificially be that age. So based on that, you can actually file the 485 and you can continue processing the green card for your child, and they will get the green card. Otherwise, they're out of luck.
Prashanthi Garu, can you tell us please what is CSPA and how does it help?
Right. So sorry for the interruption, but we had some technical issues. But as I was explaining, I think I had completed explaining that aging, if people are aging out, then they can still artificially lock their age by reducing the amount of time that it took for the I-140 to be processed and reducing that from their actual age. And then if they're under 21, then they can file the case. So that's the CSPA. And I had also mentioned that if they file the 485 based on final action dates, then they don't even have to worry about doing that, because if they were under the age of 21 when they filed, then automatically their age gets locked.
Yes, we have another caller from California. Jaya, please go on.
Hi, I have a question. Currently, I'm in H4 EAD. I'm working with an employer. The same employer sponsored me for H1, and it got approved recently. And the start date is mentioned as last week. So I would like to know the current visa status, and is my H1 is active, and I'm by myself I have changed it to H1 or not? That's my question. And another question is, if I want to revert back to H4 EAD, if I want to continue my job instead of H1 to H4 EAD, what is the procedure? These are my two questions.
So just to get the facts straight, first you filed from a H4 EAD to a H1, and the H1 is now approved. Is that correct?
Yeah.
Okay, so then the date that the H1 gets correct, that gets approved, and of course the start date is also important. That's the date that you become, because you've asked for a change of status, and if the USCIS has granted a change of status, then your status if the status is approved, then you change to the status that you have requested, which is H1, as of the date of the approval. So you're on a H1 as of the date of the approval. Now, if you want to revert back to H4, then you will have to again file for a change of status from H1 to H4, and then again file for EAD and file a H4 EAD application, and then wait. I guess you can wait on you can continue to work on a H1 until the H4 EAD gets approved. And once your H4 EAD gets approved, then you can, change your employment also in your I-9 records to a H4 EAD.
Yes, we have another caller, Fayaz. Fayaz, please go on.
Hi, thanks for taking my call and question. So the question is, my friend also applied for the EB2 to EB3, and I also applied from downgrade EB2 to EB3. My friend got the EAD, and I got the biometric appointment for this January 20th. That is the one question. So why is there difference? Because we work for the same employer, everything is same. So there is a difference in how they are handling the each application. And also one more is, if I go to India using the EAD, once I get it, I have my H1 until 2023, but it needs to be stamped. So in case if I want to come back, can I come back with EAD and still H1 will be active?
So the first question about why is each case being responded to differently, because they've received thousands of cases on the same day. So they cannot respond to each case in the same way because they don't have the ability to do that. And second thing is that USCIS is famous for not treating each case similarly. You'll have exactly the same facts, exactly the same. One case they will accept, the other case they will deny. So lack of consistency is the hallmark of USCIS. So you should be asking your congressmen and senators as to why that is happening, and hold USCIS accountable for it. But I mean, on a practical note, if they have received 10,000 applications on one day, obviously they cannot process all of them on the same day. They're going to process them throughout the week or throughout the month. So that is what most probably is happening. The second question with reference to can you travel on EAD? No, EAD you cannot travel. You have to travel on advance parole. EAD is an employment authorization document that allows you to work, doesn't allow you to travel. So if you have, presuming you meant advance parole, then yes, you can travel on an advance parole once it is approved. So you have to wait for it to get approved. Once you get the approval, if the validity date of the advance parole is still there, that means if it hasn't become invalid, then you can leave and come back during the validity date of the advance parole. And yes, you can continue to remain on H1 status even though you have re-entered on advance parole.
Yes, we have another caller. Sai, please go on.
Hi, Prashanthi. I'm Sai from New Jersey. I
Hi,
just
Sai.
want to know about the H-1B. So what happened is recently I applied for H-1B visa in Chennai, and that is on January 20th. And I figured out that my passport is going to expire in less than 6 months. So do you suggest me to travel now, or do you want me to renew it here itself? Thank you.
I suggest you renew it and then go for a visa, because otherwise they might, when you're coming back into the US, they will give you an I-94 only until the date of your passport validity. That's what they do. And then you'll have to again file for an extension. So my suggestion to you is do an expedite passport renewal, and then leave the country and then do whatever, because coming back in is the problem. When you come back in, if you don't have validity, they will only give for the validity of the passport. So that's something you need to be careful about.
Yes, before we wind up, Prashanthi Garu, and if someone needs personal legal advice from you, so can you please provide your personal information?
Yes, which was done earlier in the show, but my phone number is 212-354-1010, extension 107, or you can dial extension 0. And my email is prashanthi@reddyesq.com.
Yes, thank you so much for spending valuable time here. Thank you so much, and a pleasure to have you on our show. Thank you.
Thank you.